Forgive it.
I don't expect you to forgive. I truly don't.
This is what you did. You.
I don't think anything. False accusations in the jail.
I am devastated by what happened.
Audrey Murphy, 73, was sentenced to 20 years in prison for a deadly DUI and hit-and-run incident, but will only serve 5 years. The charges came from an accident where Murphy, under the influence, rear-ended an SUV and then fled the scene. The crash resulted in the death of 29-year-old Jamie Freeman, who was a passenger in the SUV. Murphy had previously pleaded guilty to 2 misdemeanor charges, but was sentenced to felonies in court. During the proceedings, both Murphy and her son testified about her struggle with alcohol, revealing that she had a drinking problem leading up to the incident.
Please forgive me.
It was a heartfelt courtroom as Audrey Murphy pleaded for forgiveness from the family of the woman she admitted to killing.
I don't have the words to tell you I'm sorry I am.
While on the stand, Murphy admitted to going to a bar, playing a game, having some drinks, and then heading home, which was less than 2 miles away. She said she didn't realize she had been in an accident until officers came to her house. Murphy also mentioned that her airbags didn't deploy. Prosecutor Amy Stinnett pointed out that a receipt from that day showed Murphy had consumed 5 rounds of vodka in under 3 hours.
We had a citizen who saw her continuing to drive with her damaged vehicle, followed the vehicle and recorded his encounter with her. And the only way to describe it is her hood is smashed in and she has no clue.
On the stand, Murphy admitted that, besides drinking, she had also taken arthritis medication and Percocet for pain. Her son testified that the family was aware of her drinking problem, which started after she retired in 2012.
Been a problem for majority of the family.
This is yet another tragic example of the mixing of alcohol and drugs and driving.
Judge John Brown sentenced Murphy to 20 years in prison, with 15 years suspended. After the hearing, Murphy's attorney expressed disagreement with the verdict.
Other things he should have considered, so I'm disappointed in the sentence.
In addition to the 20-year prison sentence, Murphy faces several other restrictions. She is banned from ever driving again and must remain on good behavior for 15 years and be on indefinite probation. Commonwealth's attorney Nancy Parr responded to Murphy's sentencing with a statement. People who choose to drive after drinking or using drugs are playing Russian roulette with every innocent driver and passenger on the road. Hopefully, publicized prison sentences will deter others from making such a potentially fatal decision. Alexis Rogers appeared in court for a hearing to determine if she will remain in custody until her trial. As soon as she entered her jail jumpsuit, she began crying and continued throughout the proceedings. Deputies reported that on the night of March 20th, Rogers was driving a black Mercedes on Kruse in the South Valley when a Dodge Challenger made a left turn in front of her and then quickly got back onto Kruse. This led to a confrontation and Rogers chasing the Dodge. Investigators say Rogers' passenger, Damian Luna, pulled out a gun and shot into the other car, killing Efrain Azart. Rogers and Luna then fled to Texas, Nevada, and Colorado. In court, a detective who interviewed Rogers revealed her explanation for why she didn't come forward after the murder.
She was scared of Damian. He had been beating her. That's about it.
The detective also mentioned that Rogers told him she was high on the anti-anxiety drug Xanax the night of the murder. The pre-trial detention hearing was postponed until next week to allow Rogers' new lawyer time to catch up on the case. It's unclear whether Damian Luna, the accused shooter, is in a relationship with Rogers, who just turned 19 last month. Rogers' record includes a few traffic tickets, including one for speeding and another for driving without insurance, registration, and a license. A 20-year-old man has been sentenced to 40 years in prison for killing a teen who considered him a friend. James Sotelo, who was previously out on bond for assault, was found guilty of murdering Corey Leonard Thompson Jr. A jury heard a week of testimony during Sotelo's murder trial. In March 2021, Sotelo shot and killed Corey Thompson.
I had to look at him every single day of the trial.
It took a large amount of patience because you can feel your body just shaking with anger, but you had to be patient so you don't have to go through that retrial all over again.
Sotelo testified that he shot Corey because he claimed Corey attacked him while he was asleep.
Of course, that's not true because Every shot that he had was sustained from the back. 11 of them.
Did he ever show any remorse?
Never, not once.
He never is going to take accountability for what he did. He never cared. He's never going to care. He just cares for himself. It's beyond selfish.
The jury took just 4 hours to find Sotelo guilty.
It was a relief for us to know that, okay, at least he would take some punishment for what happened.
The trial took place in the 232nd District Court, presided over by Judge Josh Hill. Judge Hill lowered Sotelo's bond amount twice.
Get out and continue to commit a crime. Again, he was caught with a and you are just on bond for murdering somebody with a it's terrible.
Judge Hill, not the jury, sentenced Sotelo to 40 years in prison.
I learned that most families don't actually get to have the moment we had today, and I'm very appreciative we were actually able to get a small piece of justice versus what other families can never see in their life.
It's better than nothing. I mean, for us, a life sentence would have been better because that's where we're sentenced to. We have a life sentence without my son.
Sotelo must serve 20 years in prison before being considered for parole. Monica Williams, accused of a fatal shooting at a Church's Chicken, appeared before a judge. Williams is charged with first-degree murder for the shooting that led to the death of Neat Roe West. Following the attack, police released photos of Williams as they attempted to arrest her. Although there is video evidence of the incident, the defense argues that proceeding with the case may not be sufficient. Williams, a 45-year-old first-degree murder suspect, was brought back into Judge Bill Anderson's courtroom, where she briefly spoke with her attorney, Scott Hall.
I have been retained.
Williams is accused of shooting Neat Roe West to death while he was working at a Church's Chicken in Orange Mound last week, following an argument. Detectives detailed the incident in an affidavit, but her attorney argues that aspects not included in the report could benefit her defense.
Viewing the affidavit, I haven't seen any list of witnesses on this case, so we may be also making a motion to dismiss.
The case has attracted significant attention, with several of Williams' family members sitting just 5 rows away from her. Williams, who appeared emotional, was seen wiping away tears, then pulling down her mask to smile, mouth words, and give her family an okay hand gesture. However, District Attorney Steve Mulroy stated that, in his view, nothing about this case is okay.
Ordinary disputes, ordinary beefs that would have just been at most a shoving match are now fatal. And it means we need tougher gun laws, but it also needs we to be extra vigilant on bringing these people to justice.
Mulroy also addressed the defense's claim regarding a potential lack of witnesses.
It is not unusual for us to get convictions based on video surveillance evidence, even if there are no actual live witnesses.
Defense attorney Scott Hall mentioned that he might request to have the case dismissed, though it's still uncertain. What is confirmed is that the bond hearing is scheduled to take place in this courtroom. Hall also noted that the bond hearing could allow the victims' loved ones to address the court. Monica Williams is expected to appear before the judge again. It was an emotional day in court, featuring testimony from a grieving mother and a remorseful teenager who struggled to hold back both anger and tears.
I said, it's a heavy day, I'm trying to be stronger.
Tina Cantrell addressed the young man she says has ruined her life.
I blame myself every day for letting him walk out that door.
Officials report that Tyler Scraggs was under the influence of meth and had THC in his system at the time of the crash. Troopers determined he was driving 57 miles per hour in a 35 miles per hour zone when he veered off the road and flipped the car. Scraggs, visibly shaken, pleaded guilty in court and turned to face Haley's family and friends.
I made a bad choice that day. Look, on everything. I had no remorse for it. It ate me alive for so long.
Offering a heartfelt apology, fully aware that it wouldn't be enough.
I don't expect you to forgive. I truly don't. I just want you to know, no matter what happens here, I am sorry.
The maximum sentence for felony DUI resulting in death is 25 years.
To take into consideration the harm you caused by your actions, and that's it.
The judge sentenced Scraggs to 10 years in prison, with credit for time served.
I would have liked for him to have a little bit more time.
As she seeks the strength to move forward, Cantrell says she prays that other teenagers will think twice before using drugs or getting into a car with someone under the influence.
All these young kids out here, don't make your mama and daddy feel the heartache that we're feeling, please.
It's been more than 2 years since a New Year's Day crash that left 4 people dead. Alex Garcia, the teen charged in the case, took a plea deal. Garcia was driving drunk in 2021 when he struck another car, resulting in fatalities. He was sentenced to time in prison. By accepting the plea deal, Garcia avoided a potential lifetime sentence behind bars, effectively giving himself a second chance.
This is what you did. You.
During his plea hearing, Corporal Christine Gracie of the Highway Patrol spoke sternly and passionately to Alex Garcia, now 18.
You don't deserve the right to call this tragedy an accident.
She even directed part of her statement to Garcia's mother.
You knew he didn't have a license, you knew he had been drinking, and by your own admission, you gave him the keys. Shame on you.
Garcia will spend the next 14 years in state prison, followed by an additional 10 years under supervision, after pleading guilty to 4 charges of DUI manslaughter and 2 charges of DUI with serious injury.
This was the right thing to do, and I think that takes a lot of courage.
The deadly crash occurred around 4 a.m. on January 1st, 2021. The investigation revealed that Garcia took his mother's Chevy Tahoe while drunk and high, driving 110 miles per hour down Flagler Street. The SUV crashed into a Hyundai Elantra, resulting in the deaths of the driver, Julia Gillard, and passengers Christian Mohib, Andras Zacharias, and Genzer Salazar.
Never been the same. Nothing has ever been the same.
Some of the victims' loved ones made statements in court.
Some people tell me to forgive. I'll never forgive you.
See, this that you decided to do that night was 100% preventable.
The sister of Zacharias spoke about multiple acts of vandalism to the victims' memorials and grave sites, which have only added to their suffering. Garcia's attorney stated that his client denounced these acts.
Him nor his family have any connection to the vandalism. They condemn it.
Garcia and his family made no public statements and left the hearing in silence.
It goes on and on and on for him, not us. Not them.
A unique condition of the plea deal is that Garcia must pay $100 annually to the crime victims as long as he remains under supervision. After 5 hours of deliberation, the jury returned a not guilty verdict for Elidor Torres, who was facing life in prison on capital murder charges. Torres was accused of being the getaway driver in the murder of 21-year-old Nathan Valdez. During closing arguments, defense attorneys emphasized to the jury that Torres had no involvement in the crime. The crime in question involved the robbery and shooting death of Valdez, who was walking near a bus stop when he was attacked. Torres' brother Leonard has since taken a plea deal in the case.
You have the power within your hands to convict a man to life without parole, but you do not have the power to convict the killer. That has not been placed within your hands. Instead, the killer gets special treatment for throwing his brother under the bus.
Convinced the jury that Elidor Torres' role didn't matter. He was still equally responsible for the crime.
Heard a lot of evidence. And at the end of the day, there's only one ultimate conclusion you can come to. There's no reasonable doubt in this case that Eduardo is guilty of capital murder.
In the end, the jury's decision favored Torres, and he was found not guilty. Meanwhile, his brother Leonard has accepted a plea deal for 45 years, with the requirement to serve half of that time before being eligible for parole. Additionally, Elidor Torres still faces another case. He and his brother were also charged with aggravated robbery for an incident that occurred 2 weeks after the murder. A jury has reached a verdict in the trial of the Florida International University student accused of sexual assault. The all-female jury began deliberations just before 1 p.m. and concluded less than 2.5 hours later. This followed some emotional testimony from the FIU student, who described being sexually assaulted and the trauma she experienced.
Count 1, false imprisonment, not guilty. Count 2, battery, not guilty. Count 3, indecent exposure, not guilty. So say we all.
21-year-old Brandon Allen was acquitted of all charges related to the alleged assault of a fellow FIU student in a dorm room.
What did you think about the charges that were leveled against you at this point, Brandon?
I don't think anything. False accusations, and the jury found me not guilty.
Did you believe all along that you would be acquitted of the charges?
I knew all along that the people would find out the truth. That's all that mattered.
The woman testified that Allen left bruises on her neck. There was DNA evidence found on her pajamas, and she broke down while testifying.
Because my roommate that was in the kitchen, we didn't get along.
And I didn't want her to know that that was happening. I didn't want anybody to know. I was embarrassed.
However, one of the 6 female jurors said she was unconvinced about Alan's guilt.
We really didn't find enough evidence to convict. Sincerely, it was just a unanimous conclusion. We didn't find him guilty of everything.
Brandon Allen claimed that the sexual encounters were consensual. His defense attorney argued that the charges were brought to cover up the fact that the woman was cheating on her boyfriend, who was in the same fraternity as Allen. The prosecutor, during closing arguments, asserted that Allen had held the woman against her will. He could have faced up to 5 years in prison if convicted of false imprisonment. The defense attorney contended that Allen had fully cooperated with the police and behaved like an innocent man throughout the investigation. Charlene Casey has been sentenced to 1 year in prison related to a tragic crash that resulted in the death of Colin McGrath. The sentence reflects the severity of the incident and the loss suffered by the victim's family.
We assess the information made available to me in light of the sentencing goals of punishment, deterrence, protection of the public, and rehabilitation. I've considered the facts of this case, the defendant's lack of prior criminal history, and her driving history, which was also made available to me. I've considered the arguments and recommendations of the lawyers, their sentencing memorandums, the letters I received, the sentencing guidelines, which were designed, among other goals, to promote consistency in the sentencing process in our judicial system. And of course, I have considered everything I've heard today. I'm also mindful of what the possible penalties are, which is the maximum penalty being 2.5 years in the House of Correction. I also want to be clear about what I'm not considering. Some things that were discussed today, and I want to make the record clear about what I am considering and what I'm not. As to what happened during the course of the arraignment is not for my consideration. It sounds as though there was some confusion over the summons. While I understand that Colin's family feels one way, and I respect that, I am not considering whether her appearance or lack of appearance as far as the sentence goes. I also know that several members spoke about her lack of remorse. It has been my experience through handling cases like this from all sides as a judge, as an ADA, and as a defense counsel, that oftentimes defendants are given advice from counsel not to speak to the family due to ongoing civil liabilities as well as the ongoing criminal case. So this is, while I've heard people make statements such as they've shown lack of remorse, often is the case that they've been instructed not to speak to you. So while again, you're free to feel however you wish, that is your right, please, I would urge you not to take her silence, meaning that she feels no remorse. That is not what I've observed throughout this trial and not what I observed today. As far as, again, I will not penalize her of going to trial. That is her constitutional right, and each defendant has that right and is permitted to test the evidence, which is exactly what happened during the course of this trial. I consider the impact of the crimes on Colin's friends and family and on Ms. Casey, as well as the continuing effects these crimes are going to have on them going forward. I've also considered the impact that any sentence will have on Ms. Casey. When I instruct a jury, I tell them they need to follow the law, whether the charge is popular or unpopular with the public. And as a judge, I expect the same out of myself in determining a true and proper sentence. I also instruct the jury throughout the trial that they are to disregard any sympathy, and they're not to allow sympathy to allow them to sway one side or the other. And today I must do the same. In this matter, there is no perfect sentence that can be imposed. There's no sentence that will satisfy all concerns as the perfect representation of justice. The court must exercise its best judgment upon the evidence presented, the verdict returned, and all the materials and arguments presented at this sentencing hearing as to the appropriate sentence to be imposed on Ms. Casey. While I agree with the defense there should be a period of probation, I also agree with the Commonwealth there should be a short period of incarceration. Consequently, I fashioned a sentence I believe will achieve all these goals. Ms. Casey, please stand. As such, I order as follows. This defendant shall be sentenced to 1 year in the House of Correction, 60 days to be served, balance suspended for 2 years. During that 2 years probation, Ms. Casey, you are to perform 100 hours of community service. And pursuant to the language of the statute, the Registry of Motor Vehicles will suspend your license for 15 years from the day of conviction. Mr. Clerk, if you could read into the record.
Commonwealth now move for sentencing. Colin, so move. Front of the Court sentence be imposed.
Yes.
Charlene Casey, the jury having returned a verdict of guilty on docket 1984 CR 00702, offense 001, charging negligent motor vehicle homicide. The court, in consideration of this offense, orders you committed to the Suffolk County House of Correction at South Bay for a period of 1 year. Court term 60 days of the sentence be served and the balance be suspended with a term of probation for 2 years. You are subject to all the standard terms and conditions of probation, as well as a special condition of probation that you are to perform 100 hours of community service. With respect to fees, the court imposes a $90 victim witness fee and a $250 head injury fee. Those fees may be paid during your probation period. With respect to notices, you are notified that there is a mandatory 15-year loss of your driver's license, and you are also notified that you have a right to appeal the convictions of this matter pursuant to Rule 65 within 30 days. At this time, the defendant stands committed.
Good luck, Ms. Casey.
Your Honor, I believe she has some time.
Yes, how much credit does she have?
Maybe 3 or 4 or 5 days or so, Judge.
All right, why don't you and counsel, are you and the Commonwealth work that out, and I'm sure I will adopt whatever you agree to. Just
very good.
Okay.
Thank you, Judge.
Thank you, everyone. Good luck, Ms. Casey.
All right, please. This court is adjourned. Thank you.
You are muted.
Get ready for a spine-chilling encounter with a villain who's even more terrifying than our last criminal. His hunger for destruction has no limits. Even the guardians of justice have fallen victim to his ruthless grip.
Don't touch me. Control yourself.
Calm down. Stop it now. So if she consciously disregarded the risk of either one of those, that element has been established. Not consciously disregarding the fact that that would happen, right? Merely consciously disregarding the risk of that happening, her ability to drive being impaired, or someone dying as a result. Merely disregarding the risk of that establishes that element of recklessness. And obviously it happened, right? It happened. The death of Officer Legeza was the proximate result of an act. Okay? The state has to prove that his death was the proximate result of an act. Proximate result is defined as the product of an act which, had it not happened, had the act not happened, the result would not have occurred. In this case, the act being Ms. Kruse driving, and the result being Officer Legeza's. Easy enough, right? Had Kruse not driven, Officer Legeza would not have died. Proximate result. And what this entire case comes down to right here. The result, the crash, the must have occurred by intoxication. Now, count one of the indictment, intoxication, is defined for you as it had to have impaired her ability to safely operate a motor vehicle by depriving her of the clearness of mind and control of herself, which she would otherwise possess. Let's look at the evidence of lack of clearness of mind in this case. All right? Let's look at her driving behavior. Driving without headlights. Remember Ms. Hawkins, a defense witness, mind you, a defense witness. And that's an underlying theme of this case, which we'll get into in a moment. Ms. Hawkins, unsolicited, this is a really dark stretch of road, and the state asked her, would you have noticed if you didn't have your headlights on at that time of morning? And the look on her face, the most obvious question of all time, yeah, I would have noticed. It's 4:50 in the morning on a dark stretch of road, yeah, I would have noticed. Driving without headlights. Driving on the wrong side of the road completely, right? We're not talking about swerving. We're not talking about crossing a center line or a fog line. We're not talking about weaving within a lane. We're talking about driving completely on the wrong side of the road. Stopping in the middle of the road. Literally coming to a complete stop in the middle of the road on Main Street. That probably goes to the last point, which we'll get to in a moment. No braking before impact. None. Even though Officer Legeza had his headlights on. No breaking. Go back to what Special Agent Ogilvy talked about divided attention tasks and how alcohol affects our ability to divide our attention. No swerving before impact. This last fact was offered by the defense. The proof in this case is so strong for the state that even when the defense elicits testimony through Officer Sergeant McCauley about the Google Map data, it's a good fact for the state. She Google Maps how to get to her house south of Franklin. So A, she drives the wrong way to begin with. She goes north when her house is south. And B, she can't even follow the map to her house. She plugs that in at 4:41. That's what the records show. Accident happens 10 minutes later. So for 10 minutes, she can't even follow the Google Map direction to her own house. This is just another example of an underlying theme here, that this case being so strong that even the defense witnesses, even the proof elicited by the defense.
In some cases, the jury's decision affects the family more than the defendant. The accused person's family may have never expected to face such a day.
As to count one, we, the jury, found the defendant guilty.
Of what charge?
Vehicular homicide, parentheses intoxication. As to count two, vehicular homicide, 0.08% alcohol concentration or greater, we, the jury, find the defendant guilty. As to count three, vehicular homicide by reckless conduct, we, the jury, find the defendant guilty. As to count four, reckless aggravated assault resulting in, we, the jury, find the defendant guilty.
Thank you. If you pass the form back to Mr. Aiken, and please have a seat. Please have a seat, Ms. Kruse. Ladies and gentlemen, if this represents the individual verdict of each of you, would you please signify by raising your right hand? As the 13th juror in this case, and exercising my role in that regard, the court finds that the weight of evidence supports the jury's verdict. Mr. Hess, at this point, is there anything further? We just need to order a pre-sentencing report.
Yes, Your Honor. Given that the defendant has been convicted of non-probatable felony offenses, the state moves to revoke her bond pending sentence.
Mr. Hoffman.
We would ask that you don't revoke her bond because she has shown to the court that she is reliable, she will not go anywhere, she will not flee, and she has shown the court that she obeys the rules of probation that have been put on her. She's had 2 different bracelets on her legs that she's been wearing this whole time, and I believe that the court can trust her until we have our sentencing hearing.
Mr. Hess.
The situation has changed now, Your Honor. She's been convicted of offenses that carry mandatory prison sentence.
The court agrees with the state, plus Mr. Hoffman, you'd have to check me on this, but I think that in fact the bonding company's responsibility to your client ends at this point. So it's not a matter of revoking the bond. I think in fact their bond obligation ends, so she will go into custody. Thank you. Anything further from the state or the defense?
Make a sentencing date, Your Honor.
We will do that. We need a pre-sentencing report. That takes about 45 days. Ms. Gray, what do we have?
Do you have your calendar?
Do not.
Are we going to do a special set?
Yes.
Okay.
2 days, maybe.
Okay.
Then I need my calendar. Ms. Arnold, if you can bring my calendar.
Just for the record, Your Honor, I understand what the court is saying about the bonding company's obligation. We would still move to revoke her bond entirely. So no.
That's fine. You draw the order. But check me on the statute. I think, in fact, upon the conviction under these circumstances, that ends their obligation. But whether it does or it doesn't, I'm not releasing her on bond.
Pending sentencing. Yes, sir. Thank you. I'll prepare it.
Okay, so let's see, we need something, it looks like, toward the end of March or the middle of April, is that right, Ms. Gray?
When given the opportunity to speak, the criminal stayed mostly silent, perhaps wrestling with self-awareness.
My name is Ashley Kruse, ASHLEY-KROESE.
When you're ready to give your statement, please do it.
I'd like to start by apologizing to the court for my actions and for what resulted from them. I obviously never meant for this to happen. And I never meant to come here to cause trouble. I actually came here because it had been my dream since I was little to live in the United States. I'm a dual citizen, so like my aunt said, growing up, I spent a lot of time in Nebraska, and every time I visited, it would just reinforce that dream. Then in 2018, my family and I came to Tennessee for the first time, and we fell in love with it. My parents and I left everything behind, and for instance, my brother was going to join us with his fiancée and my aunt with our family. It's been a struggle to realize and understand and accept that somebody lost their life that night, because I never would have imagined that I'd physically harm somebody. I accept the jury's decision, and I sincerely hope that the Legeza family can find some kind of peace in that verdict. I would have preferred to apologize to the family in a more private way, but I do understand that it's not two families that were impacted that night. It's the whole community. I can't pretend to understand what you've been going through. I've never lost a husband, a son, or a brother. And nothing I can say today will ease your pain. I know that. But I'm truly and deeply sorry. I'm also aware that I can seem cold. I'm anything but cold. I am devastated by what happened. No one's prepared to face such a thing in life. And if I'm honest, I just don't even know how to react, because there's no appropriate reaction for that kind of things. So I try to hide my emotions as much as I can. I think about you every day. His family, his friends, the people that love him. And there's not a moment that goes by that I don't think of Justin Legeza. The sentence, whatever it may be, I know it's not going to sound like a lot to you, and I understand that, and you've said it. But please believe me when I tell you that my life will not be the same either for me after that. You lost him for life, and I'm going to have to live with this every single day. I'm so sorry. Thank you for taking the time to listen.
Thank you. You may step down.
That's proof.
Very well. The defense rests.
Yes, sir.
Anything further from the state?
No, Your Honor.
Very well. The proof is closed. And instead of calling Uber or Lyft or a taxi or doing something else, she made a decision to drive. And the evidence is pretty suggestive that she put her address in her phone and went the wrong direction with her headlights off. So as bright as she is, as educated as she is, as hardworking as she is, none of that basket of attributes prevented her from making a terrible decision. So when I look at the criminal conduct involved, I agree. She did not intend to kill someone, but she did intend to drive under circumstances when she had absolutely no ability to drive. She was intoxicated over 2 times the legal limit when she was finally tested. If there had been some retrograde analysis, there might have been an even higher level of blood alcohol content. Similarly, this tragic case, and it is tragic in the court's mind from every perspective, caused Destin Legeza to lose his life, caused his family to lose their son, their brother, the husband, caused the Brentwood community to lose a dedicated officer who did more than just patrol and write tickets. I mean, he greeted people. He welcomed people into his community. He was an ambassador for the city of Brentwood. Head Minister Legeza, Officer Legeza, and Ms. Kruse known one another in life. I suspect they would have enjoyed each other as individuals. And the way they've come to know one another is tragic. The court finds, of course, that there's no question about whether she is range 1 unless I look at the issue of especially mitigated offender. The defense has argued, as was brought out in his closing statement, that there are some mitigating factors that are not statutory in nature. One is a lack of criminal history, which I've addressed. Ms. Kruse's age, she was 24 at the time of the incident, she's 26 now. Her education, character, and standing in the community, her habits amounting to an exemplary past, I've addressed those. Tremendous support from among family, friends, and others, pouring of information that's been provided to the court for its use in making a decision. Genuine remorse demonstrated by Ms. Kruse. I don't find that her remorse is feigned. I do think it is genuine. However, the legislature has stepped in the court's mind and said persons who commit the offense of vehicular homicide by intoxication shall not be granted probation. The court finds that if it were to determine that Ms. Kruse is an especially mitigated offender under the facts and circumstances of this case, it would be sending the wrong message to the community. And I respectfully decline to do that. So I do find, of course, that she is range 1. She's a standard offender. I do not find any enhancement factors that would require the court or even suggest to the court that her sentence should be enhanced beyond 8 years. And of course, I've addressed the issue of whether she should be an especially mitigated offender. I have listened to the proof. I have considered the results of the risk needs assessment, as I have discussed. And it's the court's determination that she should be sentenced to a period of confinement of 8 years with a commensurate loss of license. Anything further from the state?
The court is required to suspend her license from a period of minimum 3 years to maximum of 10 years. We're asking for 10.
I'll suspend it for a period of 5 years with the understanding that when she's released, she can apply for a restricted license.
Nothing further.
Anything further from the defense?
No, Your Honor.
Thank you all. We are adjourned.
Actually, there's one thing. I apologize, Your Honor. I think the court has Miss Kruse's passports. Could they be returned to her family?
Talk to Mr. Hess about that. It's not before me, and I'm not going to go there.
Thank you.
I'm adjourned. Thank you.
On November 2nd, 2013, in Dearborn Heights, Renisha McBride was fatally shot by Theodore Wafer after knocking on his door. As the court investigates the incident, it's worth noting that some criminals call the police themselves to avoid suspicion. In this case, Theodore Wafer did not call the police himself. Instead, the incident was reported by others after the shooting occurred.
Yes, I just shot somebody on my front porch with a banging on my door.
What's your address?
My name, address.
Okay, what city are you in?
Thank you.
What city are you in?
My assumption based on running into the parked car, and just the confused state of not knowing where she was, or not being able to give me a phone number or anything to help me out to get her, help. But
did she ever give you a phone number for home?
No, that's what I was trying to get.
Did she ever fight with you?
No.
Did she ever become belligerent?
Not at all.
Did she ever become testy or combative in any way?
No.
Did you have damage to your vehicle?
Yes.
I'm going to show you what's similar to People's Proposed Exhibit 8, 9, and 10.
No objections to 8, 9, or 10. So,
starting with People's Exhibit number 8. Can you tell me what that is?
A picture of her car in the driveway.
In the driveway at your house?
Yes.
Okay. And showing you People's Exhibit number 9. What is that? The damage that was caused as it related to this evening?
Yes.
Okay. Okay. That would be the front passenger side primarily?
Yes.
Okay.
I'm sorry, that was damage to your car?
No, this is damage to her car.
I'm going to direct your attention to this up here. Can you tell us what that is up there? Were you able to see that up there?
What? That light?
This area right here, it looks like it's on the windshield. Do you recall seeing that the night of the accident?
No, I don't.
Okay, so you can't tell us what that is?
I can't.
Okay, showing you People's Exhibit number 10. Now is that?
Yes.
What is that?
This is my husband's car.
And showing this area here, is that the curb?
Yes.
So the vehicle was pushed up onto the, almost looks like it's in the grassy area?
Yes.
Okay, and I presume that that's not how you parked the car that evening?
No.
The car would have been parked back in this general area?
Yes.
Okay, so the accident with the white vehicle pushed the vehicle up here onto the grass?
Yes.
Thank you. Did the sign the police got there?
I don't.
Do you know how long after this lone female occupant of the vehicle left that the police actually got there?
From the time I called until the time that they arrived, I believe it took about 30 minutes, maybe approximately 30 minutes.
And that was
Excuse me, Your Honor. Could we have clarification about which call she was
I'm just thinking
Thank you.
that would have been 30 minutes after the second call or after the first call? You made the first call at 12:55, and then you called for the ambulance at 1:20. Made the location.
They did.
All right. And did you speak to the ambulance?
I did.
Did you advise them of anything?
I did. I asked them to go and circle the block and look for her because she had left walking. I was worried about her. I didn't know where she was. I did everything but, restrain her from leaving. But I did want them to look for her because I knew that she was hurt and I didn't want her out there by herself walking at that time of night.
At that particular time, do you recall if it was raining out?
It was not raining.
The police come.
Police came first.
And then the ambulance came?
Yes.
And was that white vehicle towed from the scene?
Yes, it was.
And was your vehicle towed as well?
Yes. No, my vehicle was not towed that night.
Okay, stayed there?
Yes.
And then what later did you have it?
That morning I had my vehicle towed.
Go ahead, ma'am.
Renisha was a beautiful young lady with her whole life ahead of her. She was a goofy person with a smile that would light up any room. Renisha was smart, kind, and loving, and a family-orientated person. For me, she was more than just a sister. She was my best friend. We had our ups and downs, as many sisters would. More good times than bad. Renisha was the youngest sister, but she often played the role as the big sister. When I needed someone to talk to, she was always there to listen. When I cried, she was always there to comfort me. When I ran across hard times, she was always there to lift my spirits. Losing my sister was one of the most devastating times in my life. Many days I sit and think about the good times we shared and how they were cut short by a person's cowardly actions. Throughout the trial, Mr. Wafer stated how this tragedy has affected his life and how he often cried. Mr. Wafer also stated that my sister was an accident. I was taught to apologize when I made a mistake or an accident. Never once have I heard Mr. Wafer send his condolences or apologize to my family for taking our loved ones. I find it very hard to believe that his actions was an accident. I ask you today, Judge Hathaway, when sentencing Mr. Wafer, that you give him the maximum. I believe he needs time to think about his actions, like why he didn't call 911 instead of opening his door and my sister. Mr. Wafer, your actions impact a lot of other people besides just yourself. I thank God the judicial system worked and showed you as the you truly are. Somewhere down the line in life, I have to forgive you in order to be accepted into heaven myself. But I will never forget the pain, the hurt, the heartache, or the devastation you caused my family.
To the court, this man has ruined our family life. It's not a day that go by that I don't think about my daughter. I'll never have the opportunity to see her grow up, be a woman, have kids. Judge, I just hope you really give him the maximum sentence that's possible. I'm going to read a statement from my youngest daughter. My youngest daughter in the past week have had 2 panic attacks. That's why she couldn't come here. She was going to come to make this statement herself. She wanted to.
Okay, you can go ahead and read your statement.
I am, but it's affected her so much to the point where she can't get this out of her mind because they grew up together when they were young and they were the best of friends, and she really looked up to her sister. Her statement, my daughter is Lindsay Simmons. You messed up a lot of things. You broke my heart. because now I have no sister to talk to or be with anymore. We were quite close, so yeah, you ruined that. My sister was innocent and did not deserve what you have done to her. Having an older sister is very important for a girl growing up, and you threw that all away without even thinking about how it would affect others or even her directly. I hope while you're sitting all alone in that cold, dark jail cell that you will reevaluate yourself and realize that the bad that you've done and how horrible you affected people in our family. That's it.
Thank you, sir.
I apologize from the bottom of my heart. And I am truly sorry for your loss. I can only hope and pray that somehow you can forgive me. My family and friends also grieve. From my fear, I caused the loss of a life that was too young to leave this world. And for that, I'll carry that guilt and sorrow forever. I only wish that I could take this horrible tragedy back. I ask the court in your honor for mercy.
Thank you, Mr. Wafer. This is one of the saddest cases I have ever had. A young woman's life is gone, and otherwise a law-abiding citizen's life is ruined. Good afternoon, counsel. You can each be seated. We do have a verdict at this point in time. I just want to put the other notes that I received from this morning on the record. One was asking when the jury would be released for lunch, and the other was asking for a copy of the verdict form, although they indicated at that time they were not ready to vote. Before we bring the jury out here, I want to remind everyone in the audience that you are required to maintain yourselves. Anyone that does any sort of outburst whatsoever, 3 days, automatic, Wayne County Jail. I have no problem locking up entire families, and the deputies in this courtroom are aware of that. So everyone maintain yourselves while we take the verdict. Let's bring out the jury. All right, for the jury. That one right there.
You may be seated.
All right, ladies and gentlemen, which one of you, by a show of hands, is the foreperson? Okay. All right, juror, I just want to let you know that your image will not be recorded, but there will be an audio recording. I understand that you've reached a verdict?
Yes.
Okay, could you please come as close to that microphone as possible and read your verdict, ma'am? Yeah.
Is this good?
That's perfect.
We, the jury, find the defendant, Theodore Wafer, as follows. Count 1, murder in the second degree, guilty of murder in the second degree. Count 2, guilty of statutory manslaughter. Count 3, felony, guilty of felony.
Thank you very much, ma'am. Can you hand that to the deputy? You can have a seat. Ms. Carpenter, would you like to have the jury polled?
Yes, Your Honor.
Okay.
Juror number 1, is that your verdict?
Yes.
Juror number 2, was that and is that your verdict?
Yes.
Juror number 3, was that and is that your verdict?
Yes.
Juror number 4, was that and is that your verdict?
Yes.
Juror number 5, was that and is that your verdict? Juror number 6, was that and is that your verdict? Juror number 7, was that and is that your verdict? Juror number 10, was that and is that your verdict? Juror number 11, was that and is that your verdict? Juror number 12, was that and is that your verdict? Juror number 13, was that and is that your verdict?
And although the evidence clearly showed in this case that Miss McBride made some terrible choices that night, none of them justified taking her life. I do not believe that you are a cold-blooded or that this case had anything to do with race or that you are some sort of monster. I do believe that you acted out of some fear, but mainly anger and panic. And an unjustified fear is never an excuse for taking someone's life. In order to take someone's life based on fear, it has to be honest and reasonable, and someone knocking or pounding on your door at 4:30 in the morning rarely creates an honest and reasonable situation that would justify taking another person's life. So what do we have? One life gone and one life ruined. I am confident that if you weren't going to prison today, you would never commit another crime for the rest of your life. I'm also certain that you are remorseful and that you regret your actions immeasurably. However, none of that excuses what happened in this case, and I'm certain that you've thought about the family over and over again and how the evidence in this case showed that when Miss McBride was intoxicated, disoriented, injured, and regardless of whether or not she sought help, she needed help. And when she needed help, she ended up meeting her death. I fully recognize that you did not bring these circumstances to your doorstep. They arrived there, but once they did, you made choices that brought us here today. I would call it the worst mistake of your life, but I don't know that you can ever use the word mistake to describe. And a person was... I cannot go below the guidelines. In this case, your attorney wanted 4 to 7. The prosecutor's office, through people of the state of Michigan, through Kim Worthy's office, have asked for a guideline sentence, and I think that that's reasonable. I do have to assess costs. $68 state cost crime victims assessment in the amount of $130. You're going to be sentenced to 2 years for the felony conviction, which will be consecutive to the murder in the second degree and the statutory man convictions, which will run concurrent to one another. For the second degree murder conviction, I'm going to sentence you to 15 to 30 years. For the statutory man, 7 to 15 years. You will receive credit for 28 days. Mr. Wafer, you have a right to appeal your conviction and sentence with the Court of Appeals. If you can't afford an attorney, one will be appointed for you, and that attorney will be furnished with the necessary record required to handle your appeal. And that request, sir, must be made within 42 days.
Your Honor, for the record, Mr. Wafer has filled out the notice of right to timely appeal and request for a court-appointed attorney. He does request one, and I have handed it to your clerk so it can be filed.
Of course. Thank you very much. That's all.
Thank you, Your Honor. Okay. Okay, just step back.
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.